If things do not change with that, if it's not sort of a correction of the media, and we've talked about specific relief here, with it I won't necessarily have to get into, if that change, then this perception continues to exist. And so I think that that is a concern that we felt we needed to bring to the court's attention, that we do believe there has to be some type of remedy for it in order to ensure that this man who's being tried in his life is not damaged by information that is out there. We also, just one thing, I'm sorry, Your Honor, we do have a copy that we just received Friday of the plea hearing that was held in the case which is the rise of our concerns, which if the court felt was appropriate, we could share.
So you have a copy of the actual factual basis
Yes.
that you're concerned about?
Yes, yes, sir.
Well, I think I'd like to see that.
And that should have been, we have 2 copies of that? Yeah. Yeah, 3. Okay. May,
You want me to?
yes, and then we'll make sure that the state has a copy of it as well.
You want to take that up? I'll take
Yeah.
that.
Thank you. On this motion.
Well, Your Honor, it's interesting looking at the transcript where Mr. Waller specifically says that Travion, while it says stabbed, he indicated hit him first, and then Ronald Anthony took the knife from him and stabbed her repeatedly, which was consistent with Sarah's second statement. You've been provided with one of her 3 varying statements, and I believe it's going to be up to the jury to determine which one of them they believe. But it is also consistent with what Mr. Brown had given to law enforcement in terms of the defendant hitting her first and then Ronald Anthony stabbing them. So what Mr. Waller said was completely in line with what we believe the evidence will show at trial. Specifically, when we're talking about the statement made at a factual basis, it is our belief, the state's belief, that Mr. Smith participated in the killing and at least was showing at that point a gross indifference to human life. all of which are things that make him eligible for the death penalty. Any issue when you talk about a remedy, this was a horrific crime scene, and the jury is going to see not only was Miss Huggins-Jones' bedroom bloodied, but there was her blood in almost every single room of that house. You have Sarah, at any given time, except the first time when she said, "I don't know anything, that's all I know," is putting this defendant in that apartment with her, and he even puts himself there to some extent when he speaks to law enforcement, although I believe the jury will hear that he gave varying statements about what happened there that time. Mr. Waller's presentation of the facts is what we believe the true and credible evidence will say. When you're reading the transcript of Sarah Redden's July 2015 statement, she says, "What I said Travion said, I lied about." But what she says is, they went in there together to steal stuff. That's my opinion. And then the chaos happened. She doesn't know what was in there. And when we're talking about recanting, what she told us in that statement and what is clear from that is, when I said Travion said these things, I wasn't truthful about that. She never says, as they allege in their on page 3, Redden remained steadfast. Smith had not participated in the murder of Miss Huggins-Jones, even though changing her story likely hurt her ability. She's saying, Travion didn't say the things I said he said. So when you're talking about a remedy, obviously the most natural remedy for any pretrial publicity is jury selection, which is somewhere down this list of things we're eventually going to get into. But to come into this court and suggest that Mr. Waller misspoke intentionally, asking for your honor to find prosecutorial misconduct and dismiss the case, I would submit to you as disingenuous. It's something that I would suggest that if they felt that strongly about it to put it in a pleading, that they need to go to the state bar. But what they allege in attaching the WRAL article, that's not what Mr. Waller said, is that they took turns stabbing her. And that's why we talk to jurors every day about, can you keep the publicity out of your mind? You understand what the news reports is not true. Everything that you need to hear will come from that witness stand. And so I would submit to you that to characterize it, one, as misconduct on the part of Mr. Waller is excessive. Two, the own transcript of it doesn't bear it out. And then it's the state's position that he did, in fact, have something to do with this killing, which is why we're here and which is why we're trying to set this matter for trial to go forward. All of the cases that they cite in their motion talk about the prosecutor's misconduct in front of a jury while the trial is going, statements that are made during a court proceeding. And so, again, I would submit that it's disingenuous. Again, and now that you've had a chance to see the transcript, it doesn't bear out what WRAL attached. And if there was any misstatement or if there was any misunderstanding about what happened, certainly the way to address that issue is in jury selection. And I imagine this will take some time to sort those things out, but that's the proper remedy. And I would ask you to deny all the remedies that they have asked for in this regard and find that should there have been, all of the issues about pretrial publicity will have to be dealt with, including what Mr. Waller may or may not have said.
Your Honor?
Yes.
Can I respond? We obviously do not believe that this motion was disingenuous. It was one that we thought long and hard about filing. We have a strong duty here to protect a man who's being charged for his life. You cannot look at both the transcript of Sarah Redden's statement and the factual basis and say they are consistent with one another. They're talking about different parts of the conversation. It is not necessarily true when we talk about that the jury will have to decide which of the three statements are said. Only what she testifies to will be considered as substantive evidence. We can get into later battles about what can be used for impeachment and collaboration and all, but as you know, those are issues that, if it's impeachment or collaborative purposes, those are issues which the jury are told don't consider for substantive purposes. To say on the record that Sarah Redden said this and this and this, and to include Travion Smith in that, when she had later said Travion Smith did not say those things. And as it said in the statement, Ronald Anthony said that he stabbed her. There's nothing in that statement that you read that had Travion Smith participating. You know, if we describe participating, we can get into definitions, and we'll probably have the battle on the Tyson evidence issue moments later, what it actually, you know, constitutes. But the actual physically putting in the blows that that led to the death of the victim in this case. As far as the idea that we can correct this in jury selection, I mean, obviously that's going to be a part of it and all, but there are reasons why the cases talk about concerns about publicity beforehand. You know, becomes a concern with it and all. There are other remedies for it. We're not asking for a remedy for change of venue. I think that's impractical, would not be correct at that time. But if there's pretrial publicity, having some type of remedy is appropriate for it. And I think in this case, this is appropriate with it and all. As far as the differences in statements, Your Honor, you have both. You have the things that we relied on, which is a transcript of what she said, and you have the transcript of the statement. There is no mention that she made this additional statement in which she changed what she said about Travion Smith. And from the defense perspective, that is a problem, and it is a problem that infringes upon Mr. Smith's rights under the 5th, 6th, 8th, and 14th Amendments to the United States Constitution.
Plea transcript in the state of North Carolina versus Ronald Lee Anthony, and the factual basis set out there. I've reviewed your motions and the arguments. I do not find that the factual basis provided in the plea colloquy in Mr. Anthony's cases rises to the level where it's misleading or creates an undue prejudice for this defendant. I agree that to the extent there is prejudice from pretrial publicity, that prejudice is most ably cured through the jury selection process and the court's instruction to the jurors and their oaths that they take as jurors. So I would deny the motion to craft a remedy for the allegations made by the defense in this instance.
Your Honor, for the next motion that we'll hear, and which I think may be one of the longer motions, at least for my argument, that we'll be considering, it centers around the 2 United States Supreme Court cases, Edmond v. Florida and Tyson v. Arizona. We have copies of those cases. Would it be appropriate at this time to hand those up to you?
Certainly.
We're asking that this case be declared non-capital under the Edmund versus Florida and Tyson versus Arizona decisions. And I know we've talked about some of that in our motions, and I'll repeat some, but I'm going to be making some different points about it throughout this. As we start out here, Ronald Anthony has pled guilty. He's been given a life sentence. Sarah Redden's case has been declared non-capital as a matter of law under the Tyson and Edmonds decisions. And that happened at the Rule 24 hearing for her. And now the question for the court is whether Travion Smith should be the one defendant here, in this case, who's going to face the death penalty. And the decision, before it reaches it before a jury and all, it's appropriate for this court to decide that issue under those decisions. You know, is it appropriate to handle Tyson Edmonds? I think that under the Watson rulings, it is appropriate to handle Tyson Edmonds issues, and the biggest example is Sarah Redden. The facts were presented to Judge Stevens at the Rule 24 hearing. Unfortunately, that is not a transcript. We've tried to get that transcript. That's not one we had gotten yet. But in that case, it was presented. I don't think there should be any dispute about that. And they found that, no, she is not eligible for the death penalty under Tyson and Edmonds. Since you can do that pre-trial, it's appropriate for this court to review the facts, just as Judge Stevens did. And admittedly, the one difference is I think all sides, in Ms. Redden's case, both the defense and the state, agreed that it was a Tyson Edmonds issue. Here, there's not that agreement, but it was not the DA's using the discretion. It was based on the fact that under law, they could not declare the case capital because of her involvement in her mens rea in the case. One of the things that I think is important, and I'm going to address this, we talked a little bit about it in the last motion, but I'm going to address that here, is we have to look at the facts as where they stand today and not where they stood 6 months ago. Sarah Redden's current version of the statement of facts, as far as we have been known, and nobody said anything else, is what Your Honor read. You read her most recent statement. And her most recent statement does not implicate Travion Smith in doing any of the killing with it. She doesn't even herself put him in the room. She does not talk about, you know. So the fact that she's made other statements in the past does not mean that the jury, we would probably argue that the jury should not even be able to hear the previous statements. And we will have arguments about that, and that's not necessarily this is not necessarily the time and place for that. But it's clearly not the type of statements that they can get in for the purposes of substantive evidence that she previously said such and such about it. That she previously said that Travion Smith participated in the killings. It would not meet any hearsay exceptions. It would have tremendous Crawford problems under the Constitution. So we have to look at where the evidence stands right now. And the evidence where it stands right now is in that July statement with it. The combination of Tyson and Edmonds developed basically that the state has to show one of four things in order to get, in order for a defendant to be eligible for the death penalty. One is that the defendant actually killed the victim. If they show that, then the Tyson Edmonds issue, if they show that beyond a reasonable doubt, then the Tyson Edmonds issue is over and the jury can consider the death penalty. For the reasons that we have stated here, they don't have that evidence at this time. They have evidence from, we've talked about the witnesses who will testify. We talked about that in the opening. Whether it is Melvin Brown, Chris Clay, Sarah Redden playing Travion Smith's tape, they don't have a witness who's going to say that he was the one who actually inflicted the fatal wounds. The second thing that they have to show is that the defendant intended, well, the second thing that they could show that would make eligibility under Tyson Edmonds is that the defendant intended to kill the victim, that he himself had that intent that came over. I mean, there were certainly people who hire a hitman, if it meets other requirements of the death penalty statute, don't get the break under Tyson Edmonds. Those who were involved in the conspiracy to kill and had themselves a personal intent to kill the victim would be eligible. There's no evidence about Travion Smith in this case. There's no evidence of them having a conversation that talked about an intent to kill anybody beforehand. There is, in this case, none of that. One time that we often talk about is that intent can be judged by horrific injuries, and no doubt no one is going to deny for 1 second that there are not horrific injuries in this case. But the horrific injuries and multiple injuries that happened in this case reflect upon the intent of Ronald Anthony. They do not reflect upon the intent of Travion Smith, because he was not the one who did the killing. The other is that intention of lethal force to be used. It can be done for a lot of different cases, but I think the same facts we're talking about, intent to kill, the same with that. They don't have that. So what we're left with, and Ms. Shakita made a brief mention to that earlier, is that he showed that he was a major participant in the underlying felony, and he showed reckless indifference to human life. The question is, do they have enough evidence going forward to meet that requirement? So I want to talk about that, because I think that's where the argument is, and what we're going to be probably a major disagreement about that. It was one thing as I was doing research in this and all, and sort of found a commentator in a case that talked about it, and this is talked about a little bit differently in my motion, but I think it's important. The state has to show both major participant and reckless indifference. So we have to think about those as two separate elements they have to offer evidence to. It's not enough to show that he was a major participant or that he was a reckless indifference. They have to show both of those. Somebody sort of said that, I feel like I'm going back a little bit to law school, but that major participant is the actus reus part, and the mens rea part comes from the reckless indifference. So the argument, I assume, part of the argument will be, and it is a fair one, is that on the major participant was that there will be evidence out there that he was involved in participating in breaking into cars. About I think there'd be some evidence they could use to support that about breaking into an apartment earlier. This is, of course, taking the light most favorable to the state. And there are some of the witnesses who put him in the apartment. One, Melvin Brown, who puts him in the room. You could argue that he was a major participant for that. You can argue that Sarah, perhaps, even with some of the things that she was doing beforehand, was a major participant. They want to argue that Mr. Smith was more of a major participant than Sarah. Okay. The major participant part may not be where this dispute comes over. But what we're talking about is, was there a reckless indifference to human life? And that is a difficult question in figuring out exactly what the law says. And I'm going to spend a little bit of time talking about our views about that, because I think it is of vital importance in the case is we have two cases here. We have that we talk about, and they are Edmonds and Tyson in it. And they established it and all. And they do not give an exact definition of what is reckless indifference. Part of how we figure that out is we begin to look at both of those persons' activities and what came out. Obviously, the court, because in Tyson, they very clearly are not overturning the Edmonds decision. They clearly are saying we're giving more enlightening to it and all. So they were not finding that Mr. Edmonds, they agreed that Mr. Edmonds was still not eligible for the death penalty in it and all. And they did not find his conduct rising to the point of showing reckless indifference to life, human life. And that one, the facts are Mr. Edmonds, who was planned, involved, who had a history of violence himself, who helped plan the armed robbery, was out there when 2 people were killed during the robbery. And I think that I have probably even a better description of everything that went on with Mr. Edmonds in my motion, and I'm not going to reiterate that, but I think it's a description of his activity. It was not a simple innocent bystander who happened to do nothing. He had an active participation in that robbery. He wasn't immediately present when it was occurred, but he had that active participation with it. And he had a history of violence. He knew a gun was involved. He knew all of that. So the Supreme Court decided the case of Tyson versus Arizona, and then they said, you know what? There can be exceptions where the reckless indifference to human life applies. It is critical, and it will, and summarize, and it probably, the summary will be better than what I'll speak here, but I'll say it a little bit, of what the Tyson brothers allegedly did in this case and what they allegedly knew about the case. They came in with guns and they broke out their father out of jail, who had murder convictions in his past, and his father's friend who also had murder convictions in the past. They were prepared, they said in their statements, to use deadly force. They then came in and they tracked down a family of 4, knowing that they were with and doing these 2 violent men, one of them who they knew well for his violence because it was their father, and they had just done these activities, and they pulled over the car. The Tyson brothers were involved in holding the people at gunpoint during it, and they were involved, and when their father went ahead, I think it was his father, maybe the co-defendant eventually as well, who went ahead and then killed these 4 people. And the facts, as I say, better laid out in the motion I just said now, clearly in that part describe a reckless indifference to human life that they are not going to be able to establish in Travion Smith's case from the evidence that they have in front of them right now. One of the things that they talked about in this case is, in the Tyson case, is the notice that they knew that this was a dangerous man that they were dealing with, and therefore committing a crime and doing such violent acts with their father, the man of this violence, and his cohort, kind of puts you in notice that you're doing something really dangerous about it. We now know that Ronald Anthony is a bad man who's done something very violent. But that's not the question then. The question was, on the night of this offense, can the state show that Travion Smith knew that Ronald Anthony was a particularly violent, murderous person? He had a record Mr. Anthony had a record, I think, that involved conspiracy to commit armed robbery, threatening to make a bomb threat, and I may be listing out something and all, but it's nothing close to the murder, nothing close to what happened here. There was no reason to suspect that put on notice Travion Smith under the evidence in the light most favorable to the state, that he was unnoticed that this was a particularly dangerous person. There's been some testimony and in the statements of Sarah Redden, and primarily Sarah Redden, and from video statements they had of Travion about conversations that happened beforehand, but there were none that were specifically talking about violence in it. We don't have that here. One of the arguments that I think that we both, when somebody comes over and talks about reckless indifference to human life, is the idea that you may be showing it simply because you're involved in a burglary. And that is certainly, for right reasons, a very serious crime. And if there was no, and if no, even a crime that is serious partly because we know that there are serious consequences to it. But so is armed robbery. And the Supreme Court, in both Tyson and Edmonds, they talk about, and we quote the passage about that, it goes, yes, armed robbery, when they talk about it, is a really serious crime, but one for which the death penalty is disproportionate. And the fact that you participate in an armed robbery does not mean that you're by itself showing reckless indifference to human life. And the reason why they say that is as horrible a crime as armed robbery, and in no means am I trying to lessen the problems with either of those crimes, it is a crime that so very seldom ends in death or homicide. It certainly does sometimes, though. So the question comes in terms of burglary with it. How often does burglary actually result in homicide? And I can hand this up to, got statistical studies from the Bureau of Justice, special reports, and they have one, victimization during household burglaries. And what they said, if I can just for one moment find that table, is that between 2003 and 2007, approximately 2.1 million household burglaries reported to the FBI each year on average. Household burglaries ending up in homicide made up 0.004% of all burglaries during that period. And we have a copy of that study that we can show up to the state and to...
If you wish.
Yes. Thank you. The reason why we think that is relevant is because that is part of what the Supreme Court takes into consideration in deciding whether it's reckless indifference to life when it did with robberies, and we think it should be the same for you taping it about burglaries. You know, there can be other cases that talk about things, you know, was he the more responsible, more culpable person? Mr. Smith was the younger of the two defendants, had less of a record, nothing of violence. You know, he was not the leader in this case too, and I think that is a factor that you look at about. When you look at it carefully, when you study it in this way, you realize that he does not, when you analyze it, meet the culpability of the defendants in Tyson. The situation, when it comes to the reckless indifference part about it, is much closer to the defendant in Edmonds, and maybe, if we look at it even that even from the state's evidence, he is less culpable than that person. You know, one of the things that I talked about when I first started speaking was the fact that there is not, they kind of leave these words, you know, exact, you know, reckless indifference to human life, major participant, and they don't really describe what this means. It is important, I think, in this, for the Supreme Court, that the Supreme Court, in making this decision, though, and Tyson was back in 1987, is that they looked, as they often do in eighth minute jurisprudence, is to look at what are the evolving standards of decency that are involved in the case. Evolving standards of decency of society, because we don't, you know, things begin to change, and that's how they have certain ways of doing that. And that was a part of the decision. The example can simply be, you know, exactly how it looked in actual practice. In 1989, the U.S. Supreme Court said it was okay to execute the mentally retarded. 2002, they ruled, because of changes in our society and how we reacted to it and all, that we no longer, there was now a national consensus against the practice. Same with the execution of 16 and 17-year-olds. All right, in 1989, I believe it was in 2004, they changed their mind about it all. In doing that, and I only make this decision too, as you try, Your Honor, to evaluate how we're going to define this and all, we look at how society and how in North Carolina we view people who they can't show are the actual killers. And the fact is this: over the last 20 years, North Carolina has been very limited in the amount of people who it did not kill, who were sent to the death row, and every one of those cases can be distinguished from Travion Smith. There are currently 2 people on death row in North Carolina who, it is undisputed, did not inflict the wounds they killed, that it was with it. Charles Bond is one of them. That case is from 1995. In that one, Bond was the leader of a crime spree involving him and his co-defendant, in which a brother and sister were kidnapped. And Bond said, when he left, if they give you any trouble, kill them. Something like that. If I get the quotes wrong slightly, I apologize with it. But in that, in other words, he gave an order to kill. So he didn't even apply to a definition possibility of Tyson Edmonds. He applied as a leader and as the person who did the killing. And yes, he did receive the death penalty for that. Not based on something going out and that's nothing compared to what the facts were here. In 1997, we also talk about the case of, I believe his first name is Robert, but it's Brewington. In that case, he clearly was not the one who inflicted the serious wounds, but what happened there is he wanted to get money from his grandmother, and I believe it was his nephew, and he ordered the 2 people went into the house and committed arson, and who then killed the victims in a pretty dramatic way. He ordered the killing, according to the facts presented by the state and evidently found by the jury. In that case, yes, he is. So those are the 2 non-trigger people, to use that word, who are on death row. Vastly different cases than what we have here. We have the people who are masterminding it in death row. I went back, and I feel confident about the research that I did here, 20 years to see who, because obviously some people go to death row and get off for various reasons, who else has been on death row in the last 20 years who it appears was not the trigger person? At least that is the major dispute, and not just simply an allegation by the defense that they were not. And identified 3 other people. I'm just going to talk about them briefly. One is Christina Walters, who in 2000 was sentenced to death and later got relief under the Racial Justice Act. What they alleged that she did in that case was that earlier that night that she was a member of a gang, and earlier that night in a carjacking, she carjacked a woman and shot her multiple times and left her to die. Later that evening, the gang carjacked 2 other women, held them at gunpoint, and the state's theory in that case is that Christina Walters ordered the killings. And the 2 people were killed. All 3 defendants, the 2 people who did the shooting and Christina Walters, were all sentenced to death. Again, vastly different case than what we're talking about there. In terms of, and let me say, when I'm talking about different cases, I am no means lessening the horrificness or the tragedy that, that happened in this case, but I'm talking about a different case. I'm talking about this man and his involvement. Make that clear throughout it. In 2000, Christine Kennerman, who hired a hitman to kill her husband, got the death penalty. Again, this was a premeditated murder, an intentional killing. It is significant, and I'm not arguing this is binding, as the Supreme Court specifically said that, but when they reviewed the case for proportionality in the North Carolina Supreme Court, they said that Christine Kennerman's case was disproportionate. Only time, I think it's the only time in the last close to 30 years that they found the case disproportionate. And one of the reasons they gave about 3 or 4, and we do have that opinion if the court would like to take a look at it, is that that the actual killer, the actual shooter, got life. The only other case that I have been able to find regarding a non-shooter in this period was Sean Bonnet, whose case was in the 90s. I believe it was either 1997 or 1998. He was sentenced to death. He was involved in an armed robbery of a store with 2 other individuals. One man, he received the death penalty. There was evidence he was found guilty of premeditated murder because there was a discussion in the car about how they might need to go ahead and kill the victim. Evidence that we don't have there. The actual shooter and a man who remained in the car but who they believed was the mastermind, tried after Mr. Bonnet's case. And they both received a life sentence. I believe it was either early this year or last year, Sean Bonnet's death sentence was overturned by agreement of all the parties. And we have a copy of the order. It doesn't go into a lot of details, but it does say, we're dismissing everything else in the MAR. We're resisting any claim under the Racial Justice Act, but because of the interest of justice, the death penalty is no longer the appropriate case in this case, and he received a life sentence. And that's because even though there was evidence of premeditation in that case, our state has gotten to the point, and we're at the point now, that we don't execute people or do not want to put people on death row who are in the type of situation that Mr. Smith is in right now. It is a standard of decency, the evolving standard of decency, that is appropriate for this court to take in consideration. Finding. I talked about the fact that the cases that I found ranged from 1995 to 2000. I've not talked about any cases that happened in 2001 through today, because as far as I can determine, there are not any cases like that. There hasn't been anyone sentenced to death in 15 years who did not pull the trigger or do the stabs or inflict the fatal wounds with it. So if it seems that, that we are confident that this is what juries do today, we could have an argument, well, we'll just let a jury decide, and I think that's an argument that a lot of times is made and all. But there is a real danger about doing that, and it's a real danger in why we have to have these type of Watson motions and things on hand. One, and I'll just bring up this briefly because I don't think it's the most important, but it is a factor. One is we have Watsons and all because of the judicial resources that are involved in the capital case when it should not be a capital case. That is one of the issues that are involved in it all. But we also put the limitations on it for, I think, a further reason. We don't want unfair application in our judicial system. We don't want cases with people who do not deserve the death penalty. And by deserve the death penalty, I mean we're talking about based on today's society and not what was done even 30 years ago. What was done on it all. We don't want it to be influenced by passions that come out with it. And obviously, for very good reasons, this would be an emotional case and everything else. In order to do that, it becomes a judicial responsibility to apply Edmonds and Tyson, to apply the decisions, to review, take the facts that are there, to put it into the context of where we are as a state right now, and to make an implication. And it will be our strongest contention that under the facts, as they now exist, Travion Smith is not eligible for the death penalty. Thank you.
Mr. Waller.
Thank you, Your Honor. Your Honor, I would ask that you deny this motion. In listening to what Mr. Brown had to say there, one thing that was abundantly clear is there's no legal basis to do this. He talked about Watson hearings. Watson hearings are completely different. Watson hearings are based on aggravating circumstances, and they also involve, and those Watson hearings also involve prosecutorial consent. That's not what we have here. Certainly the evidence is in dispute in terms of what Mr. Brown and Ms. D think the evidence will be and what this side of the table think, or side of the aisle thinks the evidence will be in this case. But that's what the jury is for, and that's what the law requires, to let the jury decide in this case. There's no legal basis, for one, for the court to even hear this type of motion, and then two, to dismiss the case or declare it non-capital. The case law simply doesn't support that. In the Edmond case, certainly the person that was convicted and received the death penalty, one of the things that the court focused on in that case is how far away the defendant was, that he was out by the side of the road, and the only evidence putting him there was a passerby seeing him driving a car. And what I believe you will hear in this case is that Mr. Smith was in that apartment, that several witnesses will put him in that apartment, that he himself, in his initial statement to law enforcement officers, will put himself at the scene. He does not admit to going into the apartment, but right outside the door on the breezeway. So the close proximity is not an issue in this case. You're going to hear, or what the jury will hear, is about the size of the apartment. The jury will hear about the blood that was all over the apartment, and the fact that numerous witnesses will put him in that apartment. So this is not an Edmond case where someone is a aider and abetter solely to the robbery. And that brings us to the Tyson matter, which will be to consider was he a major player in the felony. And what I believe you will hear from the witness stand is that absolutely he was. That they were breaking in cars, Mr. Smith and Mr. Anthony and Ms. Redden, prior to breaking into the apartment complex. Then they broke into an apartment downstairs, and then they burglarized Ms. Huggins-Jones' apartment. That he was part of that he went in. Ms. Redden, for what defense counsel is talking about, the conflicts in her statements, has always maintained that he was there in that apartment and that he came out and that she at least saw him come out on a balcony and wipe that down. And then you have to look at what happened after the case as well. One thing that Tyson does talk about a lot about in talking about reckless indifference is what the defendants did afterwards. In Tyson, the court talks a lot about how they didn't do anything, how the defendants didn't do anything to aid the victim. That's what I believe you will hear in this case as well. That after the murder, the defendants went to a hotel, did nothing to help Ms. Huggins-Jones in any way, shape, or form. And then Tyson court talks a lot about the continuing criminal enterprise. What you will hear in this case, or I believe you will hear in this case, and that it was in fact Mr. Smith who sold the laptop that was linked to the apartment complex that got the Raleigh Police Department involved in this case. So a week later, he still has property that is found in her apartment complex. So this continuing criminal enterprise, I would submit to you, is part of that Tyson evaluation as well. And then to kind of go along with how I started this, that this was a jury question, I would cite to you State of North Carolina v. Stokes, which is 319 NC 1, and State of North Carolina versus Workman 344 NC 482, if I may approach with those cases.
Yes, sir. Thank you.
Stokes, Your Honor, stands for, again, for the proposition that this is a jury issue to decide, and that there are mechanisms in place that after we get through the case, the state can, the court can go do a directed verdict if that's what you think. But that we've got to get there first, and this isn't the proper place to decide that. Stokes talks a lot about conflicts in the evidence, and again stands for the proposition of let the jury decide those conflicts in evidence. And then State of North Carolina versus Workman, in that case it was two individuals were tried, and one of the co-defendants in fact implicated the other co-defendant, using kind of my words, not the court's words, but that was the less culpable person. And the defendant raised a claim that, hey, well, I should have never gotten here. Well, the court said, no, it's fine. It was appropriate for you to get here. And then the court took the necessary, the important steps of the jury instructions in regards to how to handle the issue. And the court also found that having a death qualified jury in a case in which an Edmund issue becomes an issue, it does not violate the defendant's right to a fair trial. So I would ask that you consider those cases, Your Honor, and then, and most importantly, pattern jury instruction 150.10 leads directly to the first question that has to be answered. And that, again, it's for a jury to decide that question. So I'd ask that you deny the motion based on those points.
Mr. Brown?
Yes. As far as the argument that this is an inappropriate place to hear this type of motion, Sarah Redden, this was not a case where the state, and I admit the state was not opposing it at the time, but the state had the option of saying at the beginning, we elect and use our discretion under, I believe it's 15A 2002, but I might be wrong about that, but they have the discretion to not seek the death penalty. They could have gone that way, and they do often in the homicide status conference hearings. That was not what happened. they gave the facts. They ruled that Sarah Redden was ineligible for the death penalty based on Edmonds, Tyson, that type of cases. She did not get it. They did not declare the case non-capital because she was cooperating. That was not the court's basis. Nothing to do with her age, race, or gender. It had to do with the fact that under the requirements of Tyson and Edmonds, she was not death eligible. If Sarah Redden can at least have the opportunity for the court to make that decision, then Travion Smith should have the same opportunity to make it as well.
Why? I mean, what precedential value? I mean, you say the state didn't oppose it. That doesn't mean that it was correct under the law to do it that way. I mean, it's...
Well, and I could have, and I guess this is a failing on my part. I do know of other cases. I've seen other cases where the Tyson-Edmonds issue has been addressed in the Watson hearing with it. The Supreme Court decisions do not, I will say this, I will admit this, they have never, that I know of, have ever found it to be error to deny a Watson motion even though it should be granted. So they're not going to go ahead and say, even if there was clearly no circumstances, they come through, and I think that's part of what the logic is in the Wookman case is you're not prejudiced by that. So yes, if Your Honor rules against us, it's not going to mean that it will get reversed. Doesn't mean, however, that's the only consideration here. It means that if the correct decision should be made, whether it can go up on appeal or not, about it at all. Particularly when that decision both involves judicial resources, which in my opinion is less of the concern, but second of all, the fairness that were involved to Mr. Smith, including the idea of having a death qualified jury when there's requirements to it. We asked what the precedential value of it is. It's a value that shows that this can be done, that it can be done if the facts support it. You can have a hearing beforehand under Tyson and Edmonds. And under the facts of this case and everything else, and under the law, you have that power. You've heard the cases, you've heard the arguments with it. I will point out that Mr. Stokes' case is a case that is decided before Edmonds was actually decided, only by a matter of a couple of months. It's so it's a 1987 case in which the Supreme Court went ahead and found the case to be disproportionate and have a death sentence in it. So that's one of the essential parts of our argument is they do have these type of Edmonds, these type of Watson hearings on this issue. Just like if the state got up and there was a dispute, and sometimes in Watson hearings there are disputes about the existence of aggravating circumstance, and the state argues our facts show aggravating circumstance, and we say no, under those facts that would not qualify as an aggravating circumstance. The court then has to decide, I've heard this, and this fact. If it is true, does it make it a death penalty case? Both sides may have genuine disagreements about the law on that part, but the judge in the court at the end has to make that ruling about it. Does it meet the elements of it? I think we have made our position pretty, I hope I have, through the motion and through argument, clear that we do not think they meet the requirements of both major participant and reckless indifference to human life, based on everything and taking into account everything about that in doing that. And that it's time for the court to go ahead and to do the proper thing and not subject someone who should not be eligible for the death penalty to a capital trial. Thank you.
All right. I'm going to, well, let me just do that. Let me just take it under advisement over the lunch recess, and then I'll read these cases and we'll talk about it first thing when we return after lunch. We'll be in recess until 2:30.
Free court stands at recess until 2:30.